Hello friends, good afternoon and welcome to the EduSide Network. Our topic of discussion today friends shall be Nature of Indian Federalism, and we are going to be looking at its continuities and the various changes within that. And to throw more light on this idea, we have with us in the studio our subject expert Dr. MP Singh, retired Professor of Political Science, University of Delhi. And with this very brief introduction, a welcome sir to the studio. So, thank you so much for being here today, and with this I also request you to begin our today's lecture.
Thank you very much, Urvashi. Federalism is a very important form of government and a way of life which is flourishing throughout the world in a big way. There was a time at the beginning of the Second World War and in the depth of the economic depression, when Harold Lasky, the great political scientist of the time, had concluded that federalism is over. The time of federalism is over because on account of the great economic depression and the World War, all political systems, including federal systems, had moved towards unitarian exercise of power, centralization, and Lasky almost wrote the epitaph of federalism. Compare that time with the time today, when political scientists today tell us on the global scene that federalism and the institution of judicial review are the fastest growing devices in constitution making in the world today. So, federalism is the wave of the present and the wave of the future. Now, today we are going to discuss elements of continuities and change in our own federal system. And we should be proud of the fact that India is one of the well-functioning federal systems of the world, not only of the global south, not only of the Afro-Asian world, but on the global scene, India is counted as a successful federal system. And in our neighborhood, a number of countries are trying to become federal. Now, to come to the country we are here to discuss today, I mean our own country, India, let's first begin with the social and cultural basis of federalism. We have adopted a federal form of government because our society is federal, and I will refer to two features of our society and culture that would explain why India has decided to adopt a federal constitution and a federal way of governance. Our society is plural and multicultural, and socio-cultural cleavages in India are more or less spread across the land from the Himalayas to the oceans. We have a diversity of languages, but we also have at least two linguas franca, along with a large number of regional languages. The number of regional languages scheduled in the constitution is 22 today, and the two linguas franca that we have adopted constitutionally as the official languages of the Union of India, Government of India, are Hindi and English. In India's past, we also had similar lingua franca in Sanskrit, later Persian or Hindustani or Urdu, and today Hindi and English are officially recognized as the two official languages of the Union of India and the languages of communication between the Union and the state governments. Now, Varnas at the all India level, Varnas at the subcontinental level, we can also say, 4 Varnas are almost subcontinental in spread or in prevalence, and although there are thousands of jatis, jatis are there, but at the same time the Varnas are only 4, and we have the 4 thousands of jatis can be accommodated into only 4 Varnas, like for instance Brahmans, Kshatriyas, Vaishyas and Sudras. Now, that is one aspect of the society I wanted to emphasize. Because of this plural and multicultural character of the Indian society, a federal form of government, a federal constitution is more sensitive to this kind of society and culture. A second feature of our society and culture which demands a federal solution, a federal constitution, is that at least some communities, linguistic and religious, are also regionally concentrated. A wide variety of cultural cleavages are spread across the nation, but there are at least some communities, regional and religious, that are also concentrated in a specific regions of the country. Like for instance, Hinduism is spread across the nation. Speakers of Hindi, the largest linguistic group, are also spread across the wide parts of the country, and a number of regional languages are there, but Hindi is somehow understood. It is the language of the market, the media and political communication almost throughout the country, with some variations. Some states are predominantly Muslim, like for instance the state of Jammu and Kashmir. Kerala also has notable presence of Muslims and Christians. Punjab is predominantly Sikh, Kerala predominantly Hindu, but the presence of Christian and Muslim minorities is notable. Goa also has significant Christian presence, and northeastern states are predominantly tribal, and some states are predominantly Christian in the northeastern region of the country. And because of these plural, multicultural and federal character of the Indian society, the Constitution of India has adopted federalism, mostly symmetrical federalism, all states or at least most states having similar presence in the federal constitution, symmetrical rights and status, but some states have been given a symmetrical recognition or rights. For example, Article 370 in relation to Jammu and Kashmir, and Articles 371, some specific clauses, particularly notably those relating to Nagaland and Mizoram, are asymmetrical in the sense that these states have been given a symmetrical recognition such that the laws made by the Union Parliament requires corresponding endorsement from the state legislatures under the provisions of the Constitution, under articles we just mentioned. Now, then let us move on to discuss some federal features of the Constitution, the Constitution under which India is governed. The President and the governors, they are constitutional heads of national or regional states. The President is the constitutional head of the federal nation, entire nation. Governors are links between the union and state governments, and a few points about their offices and their roles and functions. In terms of constitutional intents and purposes regarding the heads of the federal and regional states, these offices are supposed to be constitutional in the sense that the heads of the state are supposed to generally work on the advice of the Council of Ministers. The effective power rests with the cabinet or the Council of Ministers, and the heads of the states, federal as well as regional, are generally expected to work on ministerial advice. There are some exceptions. There is no time to go into all the specificities, but if towards the end of the lecture there are questions, we can specify these points. There have been some distortions in practice of these characters of the offices we are discussing. For example, there have been instances when presidents didn't act properly under the constitution. There are instances when governors acted in a partisan way, in a political way. These offices are supposed to be politically neutral and faithful to the constitutional values. When the emergency was declared in the country in 1975, the president then in office, Fakhruddin Ali Ahmad, did not fulfill the entire expectations which the constitution has from the holder of the office. For instance, the president could have advised or at least tried to persuade and advise, and president could have even refused to sign the proclamation of emergency unless the advice was endorsed by the cabinet. The cabinet was not consulted. The emergency was declared in the night, and the meeting of the cabinet was convened next morning, and the president didn't ask the prime minister the simple and the basic question, was this advice discussed in your cabinet or not? The cabinet was not consulted. There are instances when governors have acted in a political way, not in a politically neutral way, and thereby impeded the constitutional expectations, and state governments were dismissed for political reasons rather than valid constitutional reasons. There are instances now, of course, there are indicators now that these misuses of these constitutional heads of states' powers are much more constrained in terms of normative expectations of the constitution and the aberrations of the past regarding the exercise of presidential power and regarding the exercise of gubernatorial power. The expectations of the constitution are now better maintained. The turning point in presidential power came in the 42nd Constitutional Amendment 1976, when the 42nd Constitutional Amendment made the point which was based on constitutional convention explicit in terms of the stipulation that the president would go by the advice of the Council of Ministers, but the president will have at least the power to return the cabinet advice and ask the prime minister to request the cabinet to reconsider it. And if after reconsideration the advice is reiterated, the President will oblige the Prime Minister by signing the proclamation of emergency, or for that matter any other advice. The turning point in governor's power is a Supreme Court case, S.R. Bommai versus Union of India, decided in 1994. Before this case was decided, the Supreme Court was often approached regarding an unconstitutional dismissal of a state government, mostly formed by an opposition party, in opposition to the party in power at the center. And whenever such an exercise of power, dismissal of a state government and dissolution of the state assembly was made, if a case went to the Supreme Court did not maintain it. The Supreme Court did not entertain the case, and if at all it did, it took the opportunity to say that this is an executive domain, this is a matter within the realm of the Union executive, and the judiciary does not have anything to do with it. It is a political thicket within executive jurisdiction, not within the jurisdiction of the courts. S.R. Bommai was the first case in which instances of dismissal of state governments, a number of state governments by the Union of India, Union government, was under consideration of the Supreme Court, and for the first time the Supreme Court brought proclamation of emergency in a state under the scope of judicial review. And since then a number of cases have been decided by the Supreme Court, and dismissal of a state government or dissolution of a state assembly has been declared unconstitutional. So, this is a turning point in constitutional history of India. So, there is a gradual improvement in constitutionalization of political power in the country, constitutionalization of executive and legislative power in the country. There is no time to go into all the numerous instances and cases, but the basic point I must make. The present government, headed by Prime Minister Modi, the NDA, present BJP led NDA government, came to power promising cooperative federalism and a better deal to the state governments, and in course of this lecture we would be returning to this point. There is a good deal of reformist discourse on federalism, on union state relations, and in this context two reports are particularly significant. The Sarkaria Commission report on center state relations 1988 and the Madan Mohan Panchi Commission report 2010. Both these center state relations commissions were headed by former Supreme Court Chief Justices, and these commissions have made a number of significant recommendations, some of which have been endorsed by the Supreme Court, backed by the Supreme Court, and some of these suggestions are still expecting better compliance or implementation through constitutional amendment. Again, there is no time to go into the specifics of the recommendations of these two commissions, but these two commissions are very significant in the context of understanding and explaining the changing nature of Indian federalism. Now, briefly I would now move on to discuss some specific aspects of Indian federalism, and we will begin with political federalism. The first feature of political federalism can be summed up in the phrase executive federalism. What do we mean by executive federalism? the Constitution of India has not specifically given, given a great deal of attention to this problem, how the two levels of the government would interact, but perhaps it was not necessary. But the Constitution did have this problem in mind, and the Constitution has made some specific provisions, like for instance Article 263 of the Constitution, which makes provision for the appointment of an interstate commission, intergovernmental commission or interstate council, in fact, not a commission really, interstate council. Under Article 263, the Constitution provides for an interstate council to be appointed by the President of India, and the function of this council would be to discuss center-state relations, relations between states, among states, and for a long time this article was not operationalized, in the sense that no interstate council was set up by presidential order until 1990. In 1990, for the first time, an interstate council was created by a presidential order, and for the next 6 years the council did not meet. The first meeting of the Intergovernmental Council or Interstate Council was held in 1996, and since then the council has not met very frequently. But even though this formal intergovernmental forum has not been used much, informal intergovernmental conferences have been held frequently, regularly, frequently, and the instances are the Chief Ministers' conferences chaired by the Prime Minister, ministerial conferences, like for instance the Union Health Minister and the State Ministers of Health, Union Urban Development Minister and State Ministers of Urban Development, Union Rural Development Minister and the Agriculture Ministers of the state meeting together in conferences, or secretaries of the various ministries of both levels of the government, union and the state, meeting often frequently, often twice a year, once a year, and these conferences are quite recurrent, quite regular. If any important issue arises, such conferences have been held. And these informal intergovernmental forums can be called executive federalism, in the sense that these forums bring together at one table the executive heads of the union government and the executive heads of the state governments, and they meet together, formulate common policies, review at a common forum implementation of those policies, devise policies for the future. So, executive federalism is the most important mode of managing federal relations or union state relations in India. Recently, the present Prime Minister has set up, has abolished the Planning Commission and set up a new body called Niti Aayog, and the governing council of Niti Aayog is actually the Chief Ministers' Conference. Chief Ministers' Conferences chaired by the Prime Minister. It has become the governing council for the Niti Aayog. It was also the governing council, so to say, the approving body for the Planning Commission. The plan guidelines were given by the union government and both levels of governments meeting together in the National Development Council. another body, another intergovernmental forum informally created by a cabinet resolution by the Nehru government, in 1950. Executive federalism is the most common mode of conducting union-state relations or state-state relations in India, mostly multilaterally, although there are instances when bilateral conferences between two states or chief ministers of a particular region meeting together. There is a constitutional, or at least if not constitutional, a statutory body called, a body created under an act of parliament, zonal councils, although zonal councils have not become a very frequent institution used for conducting relations among states of a particular region, but the other bodies, multilateral bodies that we have just discussed, have become a most significant mode of conducting federal relations or union state relations in India. Now, legislative federalism is another important dimension of federal relations, union state relations. Legislative federalism differs from executive federalism in the sense that instead of executive heads of the two orders of governments meeting together, here the focus is on legislatures at the union level and at the state level interacting in some way, and here the most significant body, legislative forum of federal relations is the Rajya Sabha, the federal second chamber created under the constitution. The Rajya Sabha, as the name itself suggests, is a house of the parliament representing the states, Rajyas, or the states. It's the body of the states, as the Lok Sabha is the house of the people. The Lok Sabha is the national chamber of the parliament, and the Rajya Sabha is the federal second chamber of the parliament representing the states. Lok Sabha represents the people and the Rajya Sabha represents the states. So, Rajya Sabha is the most important institution of legislative federalism. The importance of legislative federalism historically has been secondary in parliamentary federations. In presidential federations like the American Federation, in presidential federations under the US Constitution, for example, the American Federation, for example, the Senate is the most powerful federal second chamber in the world. But that is not the case with parliamentary second chambers, I mean parliamentary federal second chambers. We are contrasting the presidential federal second chamber, the Senate in America, and parliamentary federal second chambers, the Council of States in India, the Senate in Canada, Senate in Australia, Bundesrat in Germany, and so on and so forth. In parliamentary federal systems, the federal second chamber cannot become the most powerful chamber as in the US, because the locus of power is in the Lok Sabha. Popularly, in a parliamentary system, the locus of political power, locus of people's sovereignty is the popularly elected chamber, and that is the reason why the federal second chamber tends to become a secondary second chamber, secondary chamber of the parliament. But the importance of the Rajya Sabha has become quite evident for the last 2 decades or so in particular, because since 1989 no party has got a majority after a parliamentary election, and therefore, coalition governments are formed, and even though the coalition governments have a coalitional majority in the Lok Sabha, in the federal second chamber, generally the party in power in New Delhi does not have a majority, because the Rajya Sabha reflects the political complexion in state politics, because the members of the Rajya Sabha are elected by the members of the Vidhan Sabhas in various states. So, the ruling parties in power, which are mostly different from the one in power in New Delhi these days, because of that factor, the Rajya Sabha after 1989 have had an oppositional majority, and we are witnessing every day how the present government headed by Modi, even though the Modi government has single party majority in the Lok Sabha, it faces opposition in the Rajya Sabha, and several pieces of legislation have been hanging fire because of lack of majority of the present government in the federal second chamber. The land acquisition bill has been shelved because of the opposition in the Rajya Sabha. The GST, goods and services tax, is supposed to be a very significant tax reform in the country, and negotiations have been going on between the finance ministers of the union and the state governments, yet even after 10 years of deliberations and negotiations, the GST bill has not been passed because the party with a majority in the Lok Sabha is unable to mobilize support for GST bill in the Rajya Sabha because of the oppositional majority in the second chamber. And therefore, even in newspapers for a couple of days, we have been reading that the GST bill, which was supposed to be passed during the present session of the parliament, is likely to be shelved until 2017. So, legislative federalism has become more vigorous in India. It was not so vigorous at a time when the Congress had an overwhelming majority in the Rajya Sabha as well as in the Lok Sabha. The Congress had an overwhelming majority in the Lok Sabha as well as in the Rajya Sabha, and therefore, the same party controlled both chambers of the parliament. That has not been the case since 1989, and it continues to be so till today. And therefore, legislative federalism has become more vigorous, which was rather less notable, rather dormant in the era of Congress dominance. But today, legislative federalism has become a very significant factor in the in Indian politics today. Then a third feature, a third forum is not exactly intergovernmental, but it is very relevant for union state relations. Independent regulatory authorities, I refer to the institutions called independent regulatory authorities. Such institutions are not unknown since the commencement of the Constitution, because a number of such institutions have been created under the Constitution itself. The Election Commission of India, for example, it is an independent regulatory authority, which conducts elections for the union as well as state legislatures. The Reserve Bank of India, set up under an Act of Parliament, a central legislation dating back to British India 1934. It is also an independent regulatory authority. Such institutions were very few and far between until 1991. Since 1991, after the acceleration of economic reforms, after the acceleration of neoliberal economic reforms, a series of independent regulatory commissions have been set up under acts of parliament, dozens of them since 1991 in particular. The Telecom Regulatory Authority of India, the Central Electricity Commission of India, the SEBI, Security and Exchange Board of India, the Insurance Regulation and Development Authority of India. You mention a sector of national economy and a separate institution, a regulatory authority has been created under an act of parliament, especially since 1991. Now, what is the significance of these authorities? These authorities, mushrooming of these authorities indicates a change in the process of governance. Before they got to be set up, the sectors of the economy in which they have been set up, they were directly controlled by the ministers and the bureaucrats. So, ministerial and bureaucratic direct control of these sectors of the national economy have now been taken away from them and handed over to autonomous regulatory authorities. They are supposed to be autonomous. Not every such regulatory authority is as much autonomous as they should be. Panchi Commission on Center-State Relations 2010, for example, has noted that the Central Electricity Regulatory Authority has a greater deal of autonomy from ministerial and bureaucratic control, and other independent regulatory authorities do not have the same quantum of the same degree of autonomy. The Panchi Commission on Center-State Relations 2010 has made a specific recommendation that the Central Electricity Regulatory Commission should be the model, and that structure and autonomy should be made a general feature for all such institutions. It has not been implemented yet. That recommendation is important and notable. The government also considers it significant, but at the same time, it has not been implemented, and let's hope that the Central Electricity Regulatory Authority's model is generalized for all such institutions. It can be expected that gradually we are moving in that direction. Judicial federalism, a third aspect of Indian federalism, and a very significant aspect is judicial federalism. Now, judiciary, as you know, is an institution of last recourse. Judiciary cannot and should not become a regular process of governance. It should be a process of last recourse. That is the intent, or that is also the intention of the Constitution, or intentions of our makers and the institution of our constitutional text. Yet, over the decades, we are witnessing that judiciary is becoming increasingly active, increasingly being used. Judicial activism has become a notable new development in federal governance of India, and judicial activism can be dated back, in fact, much far back in time. For example, judicial activism on constitutional issues can be dated back at least to the late 1960s and early 1970s. In protection of the constitution, in defense of the constitution, the Golaknath judgment of the Supreme Court 1967, the Keswananda Bharati versus State of Kerala judgment of the Supreme Court 1973. These are which invented the theory of the basic structure of the constitution that is beyond the amending power of the aggregate legislatures in India. These are the landmarks of judicial activism on constitutional issues, but judicial activism has spread to other areas, like for instance protection of the rights of the weak, protection of the rights of the poor, protection of the rights of women, protection of the rights of children, protection of the rights of workers, construction workers in cities, protection of the rights of the under trials. Judicial activism on these issues goes back to the late 1970s and early 1980s. Since then, the Supreme Court, a number of judges and judicial experts or jurists in the country were instrumental in changing the rules of business of the courts, constitutional courts, the Supreme Court of India and the High Courts, and the rule of locus standi was altered, changed in favor of giving a space to appear before the court to third parties. The rule of locus standi required that only the affected party, only the aggrieved party could take a case to the courts. Under PIL, public interest litigation, the process that procedure and process that started in late 70s and early 80s, under PIL, public interest litigation, rules of standi have been changed, and third parties, an NGO, any interested organization defended in protection of human rights can appear to the court for the victims who may not have the capacity, fiscal capacity or intellectual and legal capability and financial capability to the court. An NGO can stand in defense for their rights or as a party to fight for them before the courts. So, judicial activism, these two processes of judicial activism I wanted to mention, and this is a very significant development which has affected the federal governance of the country also. Federal character of the system is not left unaffected or untouched by this process of judicial activism, and it is in this context that I thought that we should discuss here while discussing Indian federalism and particularly new trends and new developments in Indian federalism. Judicial federalism as a dimension should also be brought in. There has been a significant change or at least an attempt to change the process of judicial appointments in the country. The process of judicial appointments through a collegium of judges, judicial collegium, which was started since 1993 under case law arising from Supreme Court Advocates on Record Association versus Union of India 1993, and another case or another reference, presidential reference to the Supreme Court for advisory opinion, which was offered in 1999. The concept of judicial collegium has further been elaborated. That process of judicial appointment has been in operation since 1993. That process has been attempted to be amended through a parliamentary act supplemented by a constitutional amendment by the Modi government, and the judicial collegium which prepared the panel for appointment of judges to the Supreme Court and High Courts, they were binding on the government. There was of course dialogue between the judicial collegium and the government of India, the cabinet, but once the cabinet could make clarifications, the cabinet could put its point of view to the judicial collegium, but once a panel of judges for appointment was recommended to the government of India, it was binding on the cabinet and on the President of India. Cabinet only served as a transmission agency of the advice of judicial collegium to the President of India, who issued the order of appointment. This process has now been sought to be changed by the Modi government by replacing the judicial collegium by a National Judicial Appointments Commission. And in 2015, the process of constitutional amendment was completed, and process of ratification by the state governments was also completed. President has also signed it, but it was also notified in the Gazette of India, but under a PIL, under a public interest litigation, the matter is sub judice before the Supreme Court at the moment, and the Supreme Court is presently considering the constitutional validity of this amendment. The process is not yet complete, and let us see what finally is settled so far as this matter is concerned. But it is a matter of great federal significance, because judiciary, if any institution is crucial to the working of a federal system, it is the judiciary, because any conflict of jurisdiction between the union and the states, a state and another state, and so on and so forth, any conflict between a citizen and the governments in India, where fundamental rights of the citizens are concerned, must be settled, must be decided and settled by an independent court, independent judiciary, and therefore an independent judiciary is essential to the functioning of a federal system. And from that point of view, what we are discussing right at this moment, the dimension of judicial federalism is of great significance. Now, for lack of time, I would not be going into great details of legislative relations between the Parliament of India and the state legislatures. The Constitution has very detailed provisions of ordering or organizing and stipulating law-making powers of the Parliament of India, law-making powers of the state legislatures, and how conflict of jurisdiction can be settled in terms of law-making, in terms of taxation powers, and so on and so forth. We don't have time to go into all the details and therefore I am skipping this part, and I would be making only the general point that in terms of in the realm of, in the domain of law making power, the state legislatures have certain exclusive powers, exclusive jurisdiction, state list subjects. The Constitution has 3 lists in the 7th schedule, the union list, state list, and the concurrent list. Subjects enumerated in the union list are the ones on which the Parliament of India has legislative power. Subjects enumerated in the state list are the ones on which state legislatures are empowered to make laws, and subjects enumerated in the concurrent list are the ones on which both the Parliament of India and state legislatures can make laws. They are concurrent matters, overlapping matters, concerns both orders of governments, and therefore both orders of legislatures can make laws on them. But the Constitution clearly stipulates that in case of conflict between a law made by the Parliament of India and a law made by a state legislature, the union law will prevail in cases of conflict, unless the state law has secured presidential consent, approval at the time of making of such law by referring the matter to the union government, and presidential approval for all practical purposes means approval by the union executive. Similarly, I would not be able to go into all the details of administrative relations between the union and the states. I would only make the general point that the Constitution of India stipulates, envisages what may be called cooperative administrative federalism. The executive powers of the 2 orders of governments are to be so exercised that the union and states' executive powers are cooperative with each other, and the union executive power has overriding scope in specified matters, although states also have meaningful realm or space for the exercise of their executive powers. So, the Constitution of India has a very detailed provision, set of provisions for cooperative administrative federalism. Now, fiscal federalism and interstate commerce and industry is another dimension, mainly dealing with financial and economic matters. This is also a very significant aspect of federal governance, and the Constitution of India is unique in this regard, in the sense, in comparative world constitutions, in the realm of comparative federal constitutions throughout the world, the Constitution of India is unique in the sense that we have most detailed provisions settled relating to fiscal relations between the Union of India and the state governments. No other constitution has such detailed ordering or detailed provisions for fiscal relations. For example, in Canadian constitutions, such matters are often reopened and negotiated between the federal and the state governments. Such matters are mostly settled through constitutional provision in India, and the most significant aspects of such powers relate to the Finance Commission of India, which is appointed every 5 years to study the finances of the two orders of government and make recommendations for the sharing of fiscal resources of the nation on basis of certain principles, and Finance Commission recommendations are generally accepted by the Government of India. Notably, the 14th Finance Commission, the latest Finance Commission, reported soon after Prime Minister Modi took over, and the Commission recommended that the share of state government should be increased from 32% to 42%, and the Prime Minister, the Modi government, have accepted it. That is a very significant new development in fiscal federalism. Thank you very much.
Thank you so much, sir. That was an extremely informative and interesting lecture for us. And viewers, we would like to guarantee you that we would be coming with this, more such interesting topics in the future as well. So, of course, you can also watch a recorded version of the same on YouTube. So, thank you so much, sir, again, and thank you, viewers. Have a wonderful day ahead.